agreement in restraint of legal proceedings. An agreement which prohibits or restricts a person from taking judicial proceedings in respect of any right arising from a contract is void. In other words, this section prohibits agreements which restrict an individual from enjoying the fundamental right of resorting to a court of law for redress and relief. An agreement that prevents one party from enforcing his legal rights under a contract through the legal process, that is of court or arbitration, etc., then such an agreement is expressly void. If there are more than one forum where a suit can be filed, it is open to the parties by agreement to select particular forum and exclude the other forum in regard to claim which one party may have against other under a contract. There are exceptions. There are two exceptions to section 28 as mentioned in the Act. Agreement in restraint of legal proceedings are valid if there is a reference to arbitration, if a future dispute or a past dispute is referred to arbitration, that is, if there is an arbitration clause in the said agreement, such agreement is valid. However, if the agreement states that any dispute between parties will be referred to arbitration and the amount awarded in such arbitration will be final, will be a valid contract. Another exception is curtailing period of limitation. Agreements stating the limit of time as per the Limitation Act 1963. For instance, as per the Limitation Act 1963, a suit for breach of contract may be brought within the period of 3 years from the date of the breach of contract. If a clause in agreement provides that no action should be brought after 2 years, is void. Next, number 4, an agreement, the meaning of which is uncertain. An agreement whose meaning is uncertain cannot be valid agreement. It is void agreement. If the essential meaning of the contract is not assured, obviously the contract cannot go ahead. But if such uncertainty can be removed, then the contract becomes valid. For example, A agrees to sell to B 100 kg of fruits. This is a void contract since what type of fruit is not mentioned in the agreement. But if A exclusively sells only oranges, then the agreement would be valid because the meaning would now be certain. But if he is selling various kind of fruit, in that case which type of fruit is not conveyed to the other party, and therefore in such cases the performance become impossible due to uncertain meaning, and therefore the agreement is void. Thank you. In the next lecture I am going to discuss wagering agreement. Thank you.